Hi everybody, welcome to the 13th video for Legal Studies 3-4. In this video, we're going to be looking at the VLRC, Royal Commissions, Parliamentary Committees, and the ability of courts and Parliament to respond to the need for law reform. This is the final video for the Unit 4 content. So the VLRC is Victoria's leading independent law reform body who is responsible for reviewing, researching, and making recommendations for law reform to the Victorian government. The VLRC is independent, but it is funded by the Victorian government. So the VLRC receives a term of reference from the Attorney General of Victoria. The term of reference outlines the specific issues the Victorian government wants the VLRC to investigate. The VLRC then begins its investigation and will commence community-based consultations and receive submissions from relevant stakeholders to ensure that their investigations are representative of the community's concerns. The recommendations the VLRC provides are not binding. However, 70% of the time, the Victorian government is likely to adopt them. The VLRC provides comprehensive research into a specific area and can investigate minor issues even without a term of reference from the Victorian government. However, this is very rare due to the lack of funds provided to the VLRC. And if the VLRC were to go off on their own and investigate without a term of reference, it would be in a very, very minor area of the law. VLRC investigations are also very expensive and time-consuming, so they're not suitable for urgent changes in the law. An example of the VLRC is the Commission into Medicinal Cannabis. So in 2014, the Attorney General gave the VLRC a term of reference to research the issue of legalising medicinal cannabis for exceptional circumstances. The VLRC undertook 9 community-based consultations and received 99 submissions from relevant stakeholders and provided 42 recommendations to the Victorian government in 2015. And as a result, the 2016 Access to Medicinal Cannabis Act was passed, which accepted 40 of the 42 recommendations. Another type of formal pressure is a Royal Commission. If your school has chosen to learn parliamentary committees, then just disregard the next 2 slides. So Royal Commissions are a temporary public inquiry into a legal issue. The Royal Commission has investigatory powers and can force parties to give evidence and cross-examine witnesses. The evidence provided by witnesses can also provide the basis of a DPP criminal inquiry and possibly criminal proceedings. Royal Commissions can be established at both state and Commonwealth level. The Royal Commission receives a letters patent, which outlines the members of the Royal Commission and outlines a deadline for its investigation. A term of reference is also given by the Governor-General if it's a federal issue or the Governor if it's a state issue. And that term of reference will outline the specific issue of the inquiry. Like the VLRC, the Royal Commission will investigate and hold public hearings and receive submissions from relevant stakeholders to ensure that the recommendations are representative. The Royal Commission will then provide non-binding recommendations. However, it's likely that Parliament will adopt them because they've invested a lot of time and money into the issue. Like the VLRC, it's a very timely and expensive process. An example of a Royal Commission is the Royal Commission to Family Violence, whereby the Victorian government established the Royal Commission and gave it a term of reference to eliminate family violence and assist victims. And so the Royal Commission received 12 months of investigations and 1,000 submissions. And in 2016, it provided 227 recommendations to the Victorian government. And in 2016, Victorian Parliament passed the Family Violence Reform Implementation Monitor Act, which passed all 227 recommendations by the Royal Commission. Next, we'll have a look at parliamentary committees. So if you've learnt about Royal Commissions, don't worry about parliamentary committees. So parliamentary committees investigate issues and concerns and report back to the upper house of Parliament about the need for law reform. Members of Parliament and also members outside of Parliament are provided the responsibility of investigating a specific issue and then report their findings back to the upper house of Parliament. They can gain input and insight from individuals, experts, businesses, organisations, and government departments. And if individuals with relevant information do not attend, they can be fined or imprisoned. Parliamentary committees act as a check on government because they have the power to call the government officials and government departments who are responsible for introducing legislation and actions to question their actions and reasoning for proposing certain legislation. Unlike the other two that we've looked at so far, the parliamentary committees are given a term of reference which outlines a specific issue of the inquiry. Parliamentary committees then hold public formal hearings and receive submissions and information from all relevant stakeholders. The recommendations are then published and provided to Parliament and published on Parliament's website. The parliamentary committees also have the power to investigate issues within the specific term of reference, so they don't have the ability to go out on their own. And the recommendations provided are not binding. An example of a parliamentary committee is into the end of life. So in 2016, the Victorian Standing Committee on Legal and Social Issues presented its formal inquiry into the end of life choices. The scope of reference was about end of life decisions in Victoria, and it had 1 year of investigations, receiving 1,000 submissions, 17 days of public hearings, and it heard from 150 witnesses. The Parliamentary Committee provided 49 recommendations, 45 of which were adopted by Parliament, and subsequently the Voluntary Assisted Dying Bill was passed in 2017. Now we're going to look at the ability of courts and Parliament to respond to the need for law reform. One strength of the courts to make law is the fact that they can make laws when none already exists through the doctrine of precedent. So all of this content that we're going to be looking at until the end of the video is stuff we've already learned. So these will just give you some ideas for your analysis, but you should touch on the content that you've learned throughout the course on each of these principles. So if you were talking about precedent, you could use all of the extra knowledge you know about precedents to further enhance that point. Another strength of courts to respond to the need for law reform is that they can interpret legislation and clarify the law if there are any issues regarding the meaning of acts of Parliament. Also, court hearings gain significant media attention, which raises awareness for issues in the law. As you already know, judges are independent and therefore are not influenced by political influences and political pressures, and are not self-motivated. So they are not, that because of tenure, judges don't have to worry that they will be fired because of a judicial decision. And so they can make decisions and be critical of the Parliament and government. Judges can also declare legislation invalid, and the High Court can declare legislation ultra vires if it's unconstitutional. So they can act as a check on Parliament in that way. The courts can also influence Parliament to codify principles. So Parliament can confirm common law principles into statutes and make them higher law. And the role of the High Court in acting as a guardian of the Constitution and interpreting the Constitution and ensure that it's enforced. Weaknesses of courts, however, are that judges may be bound by outdated precedents. And we've learned about that in the last couple of videos. Judicial conservatism, remember, where judges are unwilling to go beyond the literal meaning of words, means that judges may not be willing to change the meaning of a statute. Judicial activism, where judges are more willing to consider social and political factors and uphold individual rights, may be seen as breaching the separation of judicial powers because judges act as lawmakers, which undermines the Parliament's role as the main lawmaker. Parliament can also override and abrogate common law principles, so Parliament has the ability to undermine the courts. Moreover, courts must wait for an individual with standing and the financial means to bring a case before them, and judges are limited to the specific issues of the case. So even if they think there's some issue with something else that's related, they're not able to rule upon them. And finally, judges are not elected and therefore are not representative of the views of the majority. Now we're going to look at the ability of Parliament to respond to the need for law reform. Again, this is touching on stuff we've learned throughout the course, so use your knowledge to broaden these concepts. One strength of Parliament is the fact that it's the supreme lawmaking body, so it can make laws and change existing laws within its very, very broad jurisdiction. And so because of that, they can confirm and cancel any common law principles it believes are wrong or outdated. Parliament is also representative of the people and will present legislation which reflects our views and values. Parliament can also investigate the need for law reform through the VLRC, parliamentary committees and royal commissions. Parliament can respond quickly and does not have to wait for an issue to arise. It can anticipate our future needs of the community. Parliament is, however, limited by the courts and the High Court's ruling of an ultra vires decision. So even though the Parliament can override common law principles, it cannot override a decision by the High Court to declare legislation ultra vires. Parliament is also limited by the separation of powers, express rights, Section 128, Section 109, and division of powers. So even though the Parliament is a supreme lawmaking body, its jurisdiction is limited by those functions. Parliament may also be reluctant to make laws on controversial issues in fear of losing votes, and it may also represent only the views of the majority and overlook minority groups as a result of representative government, which may make politicians less self-interested. Investigations that are undertaken by the VLRC, royal commissions and parliamentary committees are also time-consuming, expensive and not binding on Parliament to adopt. And again, the composition of Parliament will affect its ability to pass laws. So going back to the first video, whether it's a hostile upper house, a rubber stamp, majority government, minority government, will enhance or restrict the ability of Parliament to pass laws. So that brings us to the end of the content for Unit 4. I hope this has been helpful, and there are some exam revision videos to assist you further.